Okay, good evening and welcome to class. Tonight we're going to look at administrative law. And if you remember several weeks ago when we were just introducing the class, we talked about this area of law just generally, and we mentioned that this is a body of law that's made up of rules, regulations, and orders from administrative agencies. And if you remember, we kicked around a couple of those 3- and 4-letter administrative agencies: the Federal Trade Commission, the FTC, the Securities and Exchange Commission, the SEC, the National Labor Relations Board, the NLRB, the Occupational Safety and Health Administration, OSHA, as we've all known. Okay, so that's basically the body of law that we're talking about here. So again, rules, regulations, and orders that come from administrative agencies. Now, by the way, we're talking about not only administrative law at the federal level, but also the state level. And since I don't know where you're going to be working, maybe in another state or around the world, what's kind of nice about working in Ohio is that administrative law and process at the state level is very similar to what it is at the federal level. So for the most part, what we talk about here as we concentrate on the federal administrative agencies, it's very, very similar and applicable to what you're going to see at the state level. Now, one of the biggest questions that pops up, of course, is why? Why do we have administrative agencies? Why do we have the Environmental Protection Agency? Why do we have OSHA? We have these administrative agencies because Congress simply can't be an expert in every area of potential regulation, every area of law. So what Congress has done over the years, 2 centuries, of course, is create these administrative agencies that essentially kind of monitor the policy wishes of Congress. So if you remember way back when, Congress will write a statute, and administrative agencies will write rules, regulations, and sometimes orders that really kind of fine-tune those statutes and become more specific, to the point where the Code of Federal Regulations comes pretty close to least in size to what we would consider all of our statutes at the federal level. So whether it's consumer protection, air pollution, protection against deceptive trade practices, and over the course of the semester, of course, we've talked about the Clean Air Act, the Clean Water Act, monitored by the Environmental Protection Agency. We've talked about the Consumer Product Safety Commission, which monitors the Consumer Product Safety Act. We've talked a lot about these agencies. Now what we're going to do is talk about the process that they use to enforce these rules, regulations, and orders. Okay, so with that said, what we're going to do is talk about the 2 types of administrative agencies. And this is important because one group actually has more authority, more independence, if you will, than the other group. So the 2 types of administrative agencies, the first are executive agencies. And your book does a good job of kind of categorizing these executive agencies by cabinet department. That's the way it ought to be. So executive agencies are found in those 15 cabinet departments within the federal government, right? So the Department of Treasury, the Department of Labor, the Department of Energy, so on and so forth. Any administrative agency housed within those cabinet departments, those 15 cabinet departments, all right, is an executive agency, okay? Now, those executive agencies are a little bit weaker in authority. They have less independence because the president can not only nominate a person for those jobs, but also can let those people go. In other words, fire them at will. No need for a reason, no explanation. Basically, those people just go, for the most part, anytime there's a change in political party control in the White House, right? So as President Obama left office, President Trump came in, those working in those administrative agencies just knew to pack their bags because they're gone. If you were within one of the 15 cabinet departments, you were within an executive agency, you were on your way out. All right? Now, let's contrast that with the administrative agencies that are housed outside those 15 cabinet departments, right? These are called independent agencies, largely because they have greater independence, all right? And although the president can certainly nominate people to work in those positions, those people can only be removed for cause. So they have a little bit more independence, right? Hence the term independent agency than the executive agency. So those who were working in the independent agencies under President Obama kept their jobs when President Trump took over. Okay? So again, a little bit more independence, a little bit more control over their particular domains. All right, so the Federal Trade Commission, National Labor Relations Board, the Securities and Exchange Commission, Environmental Protection Agency, all those agencies have a little bit more control over their domain. Okay, now, how is an administrative agency created? Well, it's created through enabling legislation, right? Enabling legislation is this big, broad, kind of macro level statute that does several things. It does set out policy, writes law, just as Congress would do otherwise. But what it also does is creates an administrative agency and then delegates a lot of authority to that administrative agency. Okay, so you think about the Federal Trade Act of 1914. Well, one of the things it did is it created the Federal Trade Commission, right? Macro level statute creates an administrative agency. That administrative agency, the Federal Trade Commission, has as part of its responsibility fine-tuning that statute. All right, so if you think about what the Federal Trade Act did, it really prohibited unfair methods of competition and deceptive trade practices. Well, the Federal Trade Commission gets to determine what is a deceptive trade practice, such as bait and switch when we're talking about consumer protection law. What is an unfair method of competition? It gets to define these things. Okay, now, macro level statute creates the administrative agency, but it needs to go a little bit further. All right. This administrative agency must have mapped out for it its powers, duties, right? Its jurisdiction, its purpose, etc., right? Those things need to be laid out. So basically kind of painting the four corners of authority for this administrative agency, and as you might imagine, this administrative agency is not supposed to go outside, right, the four corners of its authority. Okay, so as Congress creates the administrative agency, it also says, hey, you know, this is your sphere of influence and you really can't go outside that. And generally when a firm, all right, or any other regulated party believes that an administrative agency has gone outside of that sphere of authority, then that agency action will be challenged in court. Okay, so with that said, all right, one of the things we need to knock out before we look at the administrative process in detail are the types of rules that an administrative agency can promulgate. And that's kind of this big, heavy technical term, promulgate, but basically just makes the rules, right? Okay, but there are four types of rules. And if you look at your outline, the first category are substantive rules, which are sometimes called legislative rules. Now, these kinds of rules have the force of law. They're very much akin to statutes. Now, if you remember, when we were looking at really the very first class period, we mentioned that administrative law sits right below statutes in our legal framework here in the United States. These legislative rules or substantive rules really have nearly the same force as a statute, right? They're that powerful, right? And since they have the force of law, they also have to go through the notice and comment rulemaking process, which we're going to look at here in a little bit. It's in your outline, and I'll walk you through it here in a little bit, all right? But to have that kind of oomph, if you will, that power, right? Those rules have to go all the way through the notice and comment rulemaking process, okay? So, if you think about the Federal Trade Commission, it has the power to write rules, okay? Those are legislative rules, substantive rules that we've just talked about, and they have nearly the same authority as a statute. Okay, dropping down one level to a certain degree is an interpretive rule. Now, interpretive rules do not have the force of law, and therefore they don't have to go through the notice and comment rulemaking process, okay? But they're very important to attorneys and those working in a particular regulated area, because if there was ever a what if, right? What does that agency mean by a substantive rule or a legislative rule? Well, then what you can do is look at one of these interpretive rules. And these interpretive rules have as a purpose kind of interpreting those substantive rules, those legislative rules, kind of shedding a little bit more light. So the Federal Trade Commission says through an interpretive rule, this is what we mean when we say this in our substantive rule or the legislative rule. Again, those two terms used interchangeably, right? Okay. But again, they do not have to go through the notice and comment rulemaking process. And by the way, are therefore very easily changed, right? Anything that doesn't have to go through the notice and comment rulemaking process is actually very easily changed. And kind of getting back to our discussion on executive agencies in contrast to independent agencies, interpretive rules in executive agencies are, they're changed all the time. You can do it with independent agencies as well, or it does take place rather. But again, as you get changes in political power, political party power in the White House, you're likely to see a lot of change in regard to interpretive rules. Okay, policy statements. Policy statements also do not have the force of law and therefore do not have to go through the notice and comment rulemaking process. Okay, so are you likely to see a lot of change? Absolutely. Are they easy to change? Yes. Are you going to see more change with executive agencies as you see a change in political party control of the White House than you will independent agencies? Yes. Okay, however, how do you separate an interpretive rule from a policy statement? A policy statement is forward-looking. So what an administrative agency, say the EPA, might tell us in a policy statement is we are considering this. So for instance, over the next 10 years, we may consider going from 2 parts per billion to 1 part per billion in terms of what's permitted as emissions from smokestacks, and whatever that part per billion could be, benzene or whatever it might be. All right. So just kind of letting people know that, hey, 10 years down the road, 5 years down the road, 15 years down the road, we might very well change what we think is a pollutant or the level of pollutant you may be able to emit. Seen a lot of this in regard to electric cars, anything in auto emissions, I should say, so not just electric cars, but in terms of emission standards, a lot of foreshadowing, kind of letting people know what's going on. But again, doesn't have to go through the notice and comment rulemaking process, can be easily changed. Okay, orders are completely different, okay? Rules are rules, right? We talked about legislative, or sometimes called substantive, policy statements, interpretive rules. Orders are different. Orders are binding, right, on only the 2 parties in dispute. Okay, orders come from administrative agencies and more narrowly from administrative law judges that are hearing a particular case. They're hearing a dispute, right? So it might, and most likely would be, to be fair, a firm that's being regulated on one side and the agency on the other, right? And the administrative law judge, right, that works for the administrative agency issues an order that binds the agency and the regulated firm or some other regulated party. You might say, wait a minute, that doesn't make sense. Doesn't seem fair. The administrative law judge works for the agency that's hearing a dispute involving the agency. That shows you how powerful administrative agencies really can be. That's absolutely permissible. Okay, and the EPA is, well actually, let me give you a better one, the Federal Trade Commission more so. Okay, so again, 4 types of rules. Now, to kind of put these in a little bit more of an easy to remember format, if you will, all right, only one has to go through the notice and comment rulemaking process, all right, and only 2 are essentially binding, all right. The substantive rules or the legislative rules, again, 2 terms used synonymously, right, interchangeably, are binding on everybody, any party, right? Have to go through the notice and comment rulemaking process. Orders are binding, but they only deal with the 2 parties involved, right? The dispute, if you will, the parties to the dispute. Whereas the policy statements and interpretive rules, they don't have to go through the notice and comment rulemaking process, are not binding on anybody. They're really even not, if this were a semester-long administrative law course, you'd find out these rules aren't even binding on the agencies themselves. They can change them all the time, as we had mentioned a little while ago. They often do. Okay, now let's go ahead and shift to the administrative process. Now, if you look at your outline, you see that there's essentially 3 parts to this process. Okay, if you look at your outline, you see the notice and comment rulemaking process. That's very much akin to Congress making legislation. Yeah, the process is different, but you're making law, you're making the rules, all right? And again, we're going to walk through this step by step, but if you look at investigation, right? Administrative agencies have the ability to conduct investigations and often do. All right? Now, you might say, now wait a minute, that sounds a lot like the police power in the United States, the executive branch of government. Yeah, that's very truth. I mean, look at your outline. We'll go through it here in a minute. Inspection, subpoena, search warrants. It sounds very police-like, right? Well, administrative agencies have the ability to gain information, investigate, compel reports, collect information, but also tell a party, hey, you need to give us more information, or conduct searches and things of that nature. Now, lastly, part 3 here, you see adjudication. You know, I say, wait a minute, that means courts, right? A judicial process, Article 3 courts, right? Or state courts at the state level. Well, administrative agencies also have the ability to hear cases, to resolve disputes. We're using that administrative law judge we just mentioned a little while ago, and we'll further define here in a little bit. So what's kind of interesting about administrative agencies in our legal system, they're microcosms of government, right? The ability to make the law, enforce the law, determine whether you violated the law, all right? Interpret the law. All 3 of those functions housed within administrative agencies, just one administrative agency. So again, quite a bit of power. Now, administrative agencies, by the way, even with all of this, can constantly lobby Congress, tell them to change the law, recommend new legislation. The Federal Trade Commission is probably one of the best examples of this. All right, and they can certainly publish all their findings, right? So if you think, and we'll talk about that even more so when we get into adjudication. So they have all of these functions, just like a microcosm of our government, but they can also recommend new legislation, lobby just like we all do, okay? And then of course also publish what they find. So again, quite a lot of authority. Okay, so let's go ahead and look at the administrative process. Now, we're going to start with notice and comment rulemaking, which again is the legislative function of an administrative agency. And just a quick little reminder, right? Substantive rules, sometimes called legislative rules, have to go through this process, but not policy statements and not interpretive rules. So they don't have to worry about this more lengthy, I should say lengthier process. It doesn't have to take that long. Okay. Now, admittedly, the notice and comment rulemaking process can be different for each administrative agency. What we're going to do is kind of go through a process that for the most part you're going to find just about in any administrative agency. The timelines might be just a little bit different, but for the purposes today, we're going to make it a little bit easier. And for the exam, of course, go with what we cover here in class. Now, however, if you want to really discover what process an administrative agency has to follow when engaged in notice and comment rulemaking, there's 2 places to look. Number 1, you can look at the agency's enabling law, right, that we just talked about. The enabling legislation that created the administrative agency, gave it its power, authority, duties, jurisdiction, that type of thing. The other is actually a default, right? The Administrative Procedures Act, right? The Administrative Procedures Act is a statute that's actually a little over 70 years old, middle 1940s, 1946. And what it does is basically says, hey, if the administrative agency doesn't have its own unique process identified in its own unique enabling law, you just follow this, right? You just follow the Administrative Procedures Act. So another way to look at it is the Administrative Procedures Act kind of takes over where the enabling law might be silent, okay? But again, that's just for your own research and your own benefit. I mean, I think you'll find it depending upon where you're working and who you're working for and what type of industry is regulated, or more narrowly, how it's regulated. You may wind up looking at that stuff. Okay, so let's go ahead and go through the notice and comment rulemaking process that applies to substantive and legislative rules. Now, an agency has to do this when they're going to do one of 3 things, right? So they've got to go through this process with an with a substantive or legislative rule when they're going to do one of these 3 things. Number 1, they're going to create a new rule. Start from scratch, create a new rule. 2, they're going to modify an existing rule. Now again, they're still changing the law. Okay? Or 3, they're going to repeal an existing law. Okay? So number 1, they're creating it fresh from scratch, brand new. 2, they're going to modify it. So, maybe we'll go from 2 parts per billion to 1 part per billion, or something like that. Or brake pressure on an automobile needs to be set from here to here, something of that nature. Okay? That's modifying an existing rule. Or 3, they're just going to get rid of it. All right? In any one of those cases, they're still changing the status of the law, right? So they're going to have to go through this process. Now, step 1, as you see on your outline, okay, is essentially the notice itself, right? So any administrative agency that wants to create a substantive or legislative rule has to give the public notice. And the public is really everybody. It's you, it's me, it's any interested party, any regulated party, anybody. Okay? Now, the question becomes, where do you find this notice? And you find it in the Federal Register. And the Federal Register is a daily publication, 5 days a week, daily publication from the United States government. Covers all administrative agency actions, basically saying, hey, world, this is what we're looking to do. Okay? And it's got some other stuff in it too. But for your general counsel's office, this is going to be daily reading for them. All right, this is something they're going to have to at least, they don't have to read the whole thing, but they have to at least skim through it to find out whether their firm is actually being affected somewhere. All right, because of something that is taking place within an administrative agency. Okay, what has to be in the notice to be good? Okay, number 1, and most importantly, as you can imagine, all right, the proposed rule, the proposed new rule, the proposed modification, or what is being proposed in regard to scrapping a rule, right? Getting it out of the way, if you will. Okay, so that's one thing. Essentially, what's the law going to look like when we're all done? Okay. Number 2, where and when hearings will be held. Okay? Now, an administrative agency has a responsibility to hold at least one hearing. Now, again, enabling laws can do different things. All right? But at least one hearing, one public hearing where people can go talk about their opinions, voice their concern or support, what have you, in a public setting. Okay, and then lastly, the notice does have to cite the administrative agency's authority for creating a new rule, repealing an existing rule, right, or modifying an existing rule. Okay, so that authority, now again, all the administrative agency is going to do when crafting the notice in the Federal Register is just cite their enabling statute. Okay, maybe some hiccups from time to time, but not a big deal. Okay, so that has to be out there. Okay, now, second, if you look at your outline, is the comment period. Okay? Now, this is the period whereby any interested party, right, can submit comments, right, hence the term comment, on the new rule, modification of the existing rule, or the repeal of the existing rule. All right, they can comment as they wish, right? They can comment in support. They can comment in opposition. They can be an interested party who might be, for instance, a university researcher and just wants the world to know, hey, this is what's going to happen, good or bad, right? Maybe a neutral party, in other words, saying, hey, this is what you have to look out for. And I think it's interesting here in late 2017, as you know, we're almost into December, as our country has this national discussion on tax reform, you're seeing a lot of that, right? Again, not necessarily dealing with individual IRS rules, but you're seeing a lot of that public comment. I think it's healthy. You're seeing some nonpartisan groups come forward. I think that's fantastic. That's what you ought to see in a democracy, right? Okay, now, the notice and comment rulemaking period, all right, has to have at least a 30-day period for comments. Okay? Now, admittedly, many administrative agencies go a lot longer than 1 month, go a lot longer, right, than 30 days. Okay, but it has to be at least 30 days. But again, you might find an FTC or an EPA or SEC or OSHA standard that might be just, excuse me, a little bit different. Okay, now, during this period, don't be surprised if you're not asked to go lobby on your firm's behalf. Now, you can certainly do that. Even during the comment period, you can contact an agency regulator directly, in person, mail correspondence, email correspondence, Skype, whatever. There's nothing illegal about it, okay? However, this is what we call an ex parte contact, and it does have to be disclosed, and that's it, right? If you are one of the agency regulators, it's up to your responsibility saying, hey, somebody from ABC Corporation contacted me on this proposed rule modification, right? It just has to be revealed, all right? And essentially there has to be like a little short blip in the agency's records as to what was discussed. It doesn't have to be, you know, an essay or anything like that, but just at least enough to the point where an interested party could certainly identify it. Okay, now, but they're not illegal. Okay, lastly, we have the final rule. Okay, now the final rule will be published once again in the Federal Register. Okay, and the final rule, again, the brand new rule, the modification, the repeal, whatever the new status of the law is, will not be effective for at least 30 days. Now, many administrative agencies will go much further than that. They might give you years to get ready. Okay. Almost like it's a policy statement, right? Letting people become aware that, hey, by the way, you gotta change things. But nonetheless, at least 30 days, okay? Now, we're gonna look at the Small Business Regulatory Act here in a little bit that actually gave small businesses 60 days, kind of gave them an extra one, okay? Now, the final rule, however, has to be substantially similar to the proposed rule in the original notice. Okay? Now, if it turns out the final rule is something much different, then the administrative agency has to go through the process all over again. Okay? Now, have there been points of litigation over whether the final rule matches the proposed rule? Yeah, often, right? Especially for a party that's going to be negatively affected by the final rule. That party was probably going to be negatively affected by the proposed rule as well. But nonetheless, they're going to attack it. And maybe they can't attack it on the merits, right? The substance, but say, hey, the process is wrong. And basically say, hey, it's not substantially similar. You've got to go through the process again, therefore delaying the change in the law and maybe even taking another shot at defeating it during the comment process. Okay, so again, a lot of this is a very, very political process, but nonetheless. Okay, so again, if it's substantially similar, it's golden, right? At least 30 days. If it's a small business, 60 days. Administrative agencies can certainly stretch that into years, saying, hey, you've got 5 years to get ready. All right, you've got to change the protective coating on your underground storage tanks in 5 years or 7 years or whatever. Okay, but again, if it's not substantially similar, it's got to go through the process again. Now, how do you know whether something's substantially similar? I'll just give you a percentage that was shared with me a long time ago. You're not going to find it in the rules, but 90%, right? So if it's 90% similar, right, measuring the final rule from the proposed rule, you'll probably be okay. All right. Okay, now, inspections. We're going to transition to the more law enforcement arena for administrative agencies. Administrative agencies certainly can write rules, right? But they also can investigate whether they have been violated or not. And there are three chief ways in which administrative agencies do this. The first is through an inspection, okay? Now, that means literally, you know, coming to the shop and saying, hey, we want to see this stuff. Now, some administrative agencies have to give notice, others do not. Sometimes the administrative agency has to give notice itself and sometimes it doesn't, depending upon what rule might be in violation. Okay, so some agencies yes, some no, and even within the same agency, really depends maybe on what rule has to be violated. Now, with that said, the search can be of any plant. And when I say plant, it doesn't have to be, a machine shop or iron works or a foundry or something like that. It can be an office building, okay? But plants, factories, office buildings, university campuses, certainly all those things would be in play, okay? Now, with that said, think of the more dangerous places, right? Coal mines, heavy manufacturing plants, things where you really do need to get in and look around. Any situation where the damage potentially could be to the environment, right? When we were looking at environmental law, we were talking about some of the potential damage there associated with point sources, what the EPA can certainly measure, okay? Testing emissions, things like that. So it can, think about OSHA, right? Any type of workplace safety. We had mentioned several weeks ago when we were looking at employment law that no worker can be forced to work in dangerous conditions. How do you know what a dangerous condition is? Well, OSHA will show up and they'll tell you, okay? Now, with that said, all right, what happens if a firm, a regulated party, believes that the request for the inspection goes too far? All right, that, hey, wait a minute, I don't mind you coming here, but there are things you don't need to see. You don't need to look at our files. Okay, now I would say a couple of things. Number one, if you want to contest it, that's fine, you'll probably lose. All right, generally enabling statutes are written very broadly by Congress. The rules are written broadly as well by the administrative agency. But if the regulated firm, the party, wants to attack it, they can, and that's something that's going to go to court. Now, better solution is probably just to say, you know what, maybe it's out of bounds, but go ahead, come on in. Okay, there's nothing better than establishing a good relationship with inspectors, right? Inspectors working for these regulatory agencies. What's worse, a bad relationship with those parties that are probably going to show up a lot more often if you're telling them no, 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 and no, right? And they'll just become much more hostile. Now again, if you know you're not in compliance, best thing to do is probably just be honest about it, right? And then ask the administrative agency as to how maybe best to remediate that, how to fix the situation quickly. Okay. Again, it's not to say you're going to escape fines and some penalties and things of that nature, but it will look as if you're being cooperative, and you are, and that makes sense, and that you're doing whatever it is you can to make the air and water safer, or your employees safer, or something of that nature, or making sure that you're not trading in bonds you're not supposed to be trading in, or that you're giving full disclosure in a prospectus. Just kind of thinking a couple of the issues that might pop up with this Securities and Exchange Commission. Okay. Now, one of the problems, however, of course, is if you say no to an inspection, they can also come back with a search warrant, which we'll talk about here in a bit. Okay, now, a little while ago we mentioned that administrative agencies can seek information. They can ask for information. They can say, hey, you need to give us this.